application, they have a right to do so. They have a right to file their application. We will be served. And also, Your Worship, the fact that the other party intends to review or intends to appeal does not mean that the application cannot proceed before this honorable court. Whether it was the appeal or whether it will be the review. There is no application for the stay of proceedings in terms of Section 63 of the Criminal Procedure Act, pending the finalization of the review that the state intends to bring. Therefore, it is my submission, Your Worship, that the clients are suffering prejudice from day one in August, when they firstly approached this honorable court for their application to have the bail condition that is preventing them to go back to work and be able to execute the duties in terms of the SAPS that are empowered on them. There has been an unreasonable delay up until today. Therefore, it is my submission, Your Worship, that the applicants are suffering prejudice because they are unable to go to work. And if I may put it to the attention of this court, that the issue of bail condition is a matter of agency. Because after the bail condition was granted, it appeared that they are unable to execute the duties. That is the main reason they came before this honorable court. If the court is going to allow the time that is unknown to this court, there are no papers that have been filed with no date when that matter will be set for hearing in High Court. So it means the applicants will be prevented from going back to their work when the suspension of when the letters of their suspension from work has been lifted up by the National Commissioner. The National Commissioner, the state is aware that the National Commissioner has lifted up the suspension and had said under oath, Your Worship, that they must go back to work. That is the reason we are here. We had to approach this honorable court to have that bail condition amended. In the event, my Lord, I submit that the court is inclined to grant the state, which has never happened in our law, to grant someone to proceed with the review because we have no papers that have been filed in court. I would ask that the bail condition that we are asking that it be amended pending the finalization of the review that the state intends to file. Secondly, my Lord, this is a bail application. The ruling for the magistrate is not even appealable. And it does not necessarily mean that the ruling on recusal. Until that decision, because even that decision, even if it can be granted in High Court, we are making submissions on speculations which were not allowed to address His Lordship on speculation of the review, of which we don't even have the text of such a review. It's my humble submission, Your Worship, that this matter should proceed before this honorable court today, to allow the applicants to go back to work pending the finalization of the review by the state as the court is.
The police background of the issue as it is at the moment is exposed. You are advocating for the limitation of the appeal condition for heard by my brother, Mr. Masambi. I'm informed he recused himself from the case in the light of what transpired at the Commission and the Parliamentary Committee. Today, the prosecution has given me an indication they intend to file for review of the Masambi's decision to recuse himself from the case. The application is being opposed by Mr. Khumalo on the basis that the prosecution has not shown that there are prospects for success of the review application. I have to say that the intention by the state to file a review is an inter process. In any case, in that case, if there is an interrogatory process, it has to be disposed of before we can get into the main issue. And the intention by the state to file a review has not required permission from me. They can bring without permission. Unlike in a criminal case where an accused has been convicted and sentenced, and one of the parties want to appeal, they have to bring an application for me for leave to appeal my decision. With a review, as it is an interrogatory process, they don't require my permission. All they are required to do is to give me notice that they intend to do that, and I cannot stop them. So we have to allow them that opportunity and see what the outcome of the review is. Mr. Khumalo has submitted that if I grant the state that permission, then I must relax the bail conditions. The relaxation of the bail conditions is the bone of contention in this case. I cannot make a ruling before I've heard the prosecution and the defense on the issue. In the circumstances, I will allow the prosecution to file their review. The main issue cannot be dealt with today until we have the outcome of the review.
Already there was a date. What is the date? 6th November was the date to which the main case has been postponed to. May this be accused also then the matter be postponed to the same date. In the interim, we'll be filing our documents before the end of business today. Proof of service of our notice that the High Court will then be provided to the legal representatives. The 6th of November. The accused are on bail of 10,000 rand each.
Is the date in order, Mr. Khumalo?
And that the matter be remanded back to court 16th November.
Is the date in order, Mr. Khumalo?
Yes, the matter is adjourned until the 6th of November.
Matter is then remanded 6 November 2025, court 16 for outcome of the review application, be in court 8:30. Call it again.